So turning to the second line, you'll notice there's something called a provisional. Now, the provisional comes in very handy for inventors who look at the first line and they say, you know, I don't want to spend this kind of money on an invention that hasn't proven itself yet, or I don't have this kind of money to spend. So the provisional is basically like a junior varsity version of a utility patent application. What it does, it's not really a patent. A lot of people say, well, I've got a provisional patent. You really don't have a patent. You have a grace period. You've bought yourself 1 year of patent pending status. Now, provisionals are very useful because for not a whole lot of money, usually about half the cost of a utility patent, you can become patent pending. And you can spend that year doing basically whatever you want. Do some more R&D, do some test marketing, try to bring in investors, even try to sell your patent rights outright to somebody else. And you can pretty much use that year as experimentation time. And at the end of the year, you have to, if you want to continue to protect your patent rights, you have to file a utility patent application within a year of the filing date of the provisional that claims back a priority date of the filing date of the provisional application. So it's a great way to give yourself a year to kind of test market your invention, see if you can improve upon it somewhat, and basically see if you really want to spend the money doing the full-blown utility patent application and going after major market share through huge promotional campaigns or things like that. Now, there are a couple of Achilles heels to provisionals. We'll be going over those in a little bit, but suffice to say, you can file a provisional for usually, at least at our law firm, between $3,000 and $6,000. It does get you a year of grace period during which you are patent pending. You can call yourself patent pending. It gives you a wonderful opportunity to again, tweak your idea a little bit, do some more R&D, test market it, see what the consumers say, come up with some prototypes, try to refine your prototypes, and basically use that year to your advantage. Provisionals can be filed on everything that utilities can be filed on, so basically substances, methods, and machines or apparatuses, and a provisional is not renewable like a utility patent. Now, a lot of people say, well, why don't I just file a provisional, then file another provisional within a year, then file another provisional? Well, if you want to and you don't disclose your invention, you can file provisionals for 50 years if you want. The problem is that a utility patent can only reach back and grab the filing date of a provisional filed within a year of the utility patent application. And so if you file 15 years of provisional applications and then somebody independently discovers your invention and files for their own application, say 8 years into the 15 years of provisionals, they can actually have a patent issued before you even get around to filing your utility patent application. So provisionals are great for grabbing yourself a year, but be sure you use that year well, and be sure that before the end of that year you have done enough research to make a really knowledgeable decision whether or not you want to file a utility patent that reaches back and grabs the filing date of the provisional.